Good morning. My name is Aaron Demerson, and I'm the Commissioner representing employers at the Texas Workforce Commission. On behalf of the 565,000 Texas employers and 2.6 million small businesses, I'd like to welcome you all to our fourth Lunchtime Live Employment Law session. There have been over 7,000 registrants on the first few sessions, and we appreciate your attendance, especially if you are a returning employer. Now today, you will hear from three of our employment law attorneys, Tommy Simmons, Belisa Chapa, and Mario Hernandez, who will present on three topics: policies and procedures during COVID, allowable workplace health screens and medical exams, and Payroll Tax 101. They will also take some time at the end of their presentations to answer some of your pre-submitted questions. Now, this is the month of November, a special month in many, many ways. And one very special day in November is the recognition of our veterans on November the 11th, Veterans Day. And so before the team gets into those presentations, I'd like to highlight our We Hire Vets Employer Recognition Program. In honor of Veterans Day, today we will recognize three employers who qualify for this program. Through this program, in partnership with our friends at the Texas Veterans Commission, employers whose workforce is composed of at least 10% veterans are eligible to receive a We Hire Vets decal to display on your storefront or on your website. We've already given recognition to many employers, both large and small. And we know all veterans bring a level of leadership, integrity, and honor to a company that will strengthen any business, and we want to commend those employers who have hired our nation's heroes. If you are an employer that might qualify, you can sign up online at www.texasoperationwelcomehome.com. Again, texasoperationwelcomehome.com. Now I'd like to ask Dee Cote, the Veterans Employment Services or Operation Manager from the Texas Veterans Commission, to have a few brief remarks. If Dee's on the line, I'd like her to join us. And if she's not on the line, I'm going to ask Bob Gear, who handles all of our Veteran Affairs initiatives here at the agency, to make remarks on her behalf. And so Dee, if you're there, we'd like to hear from you. And Bob, I don't hear Dee right now. She may be having technical difficulties, and so I'll turn it over to Bob Gear to make remarks on behalf of the Texas Veterans Commission.
Thank you, Commissioner Demerson. Good morning, everyone. Thank you for being here today. I'd just like to say a huge thank you to all the employers who are hiring Texas veterans. Veterans bring a tremendous set of skills, attitude, discipline to the workforce, and this program that we created jointly between the Texas Veterans Commission and the Workforce Commission is our way of honoring and recognizing the employers whose workforce is comprised of 10% or more Texas veterans. Between the Texas Veterans Commission Employment Services Program and the Texas Veterans Leadership Program, we are able to help you hire veterans and also to help you apply for this recognition. Thank you, Commissioner Demerson.
Good, Bob. Thank you so much for all that you do individually, and to the Texas Veterans Commission for all that they do as well. And we're very proud of the partnership and the relationship that we have with them, and we're looking to do even more as we go forward, especially during this pandemic time. And so without further ado, I'd like to recognize three Texas employers that have gone above and beyond to hire our Texas veterans. The first on the list we'd like to recognize, and a good friend of mine, the Pflugerville Community Development Corporation. Their workforce is made up of 25% veterans, and here to accept their award is the president and CEO, Amy Madison. If Amy's on the line, I'd like Amy to have brief comments or remarks, and if she's not on the line, between Bob and I, we'll accept that recognition on their behalf. And so Amy, if you're there, we'd like you to have brief remarks.
Commissioner, Amy was not able to get through on the live event. She is on the event, but sent this statement on behalf of the Pflugerville Community Development Corporation. Ms. Amy Madison stated the Pflugerville Community Development Corporation is proud to be recognized for the We Hire Vets program and have participated since its inception. Our organization is a Type 4B development corporation in the state of Texas and receives a 0.5 cent sales tax to fund economic development in the city of Pflugerville. We provide recruitment and retention services to our local businesses. Our local population is 12% veteran, so they play an important role in the workforce pipeline. As a member of the program, we have not only hired veterans, but we have also worked to bring another 6 companies into the program in our local community. Thank you for recognizing this strong workforce in our state. And more importantly, we thank the veterans for continuing to support this country with the excellent skills that they bring to the table for all of our organizations and businesses. Again, that was a statement from Amy Madison, Executive Director of the Pflugerville Community Development Corporation. Thank you, Amy.
Okay. Thank you, Kim, for reading those remarks from Amy. And again, a good friend, one that's really working hard in that community. And just thanks for even bringing additional employers into the fold as well. And so next, we would like to recognize the Workforce Solutions Capital Area. Their workforce is made up of 11% veterans. And here to accept the recognition on their behalf is the President and CEO, Tamara Atkinson. If Tamara's on the line, Tamara, we ask you to make remarks, and if not, between Bob and I, will accept that award, that recognition on behalf of Tamara. All right, and Tamara is with the Workforce Solutions Capital Area, another stalwart worker, employer here in our community, making a difference with our veterans. And again, their workforce is made up of 11% veterans in that regard. And so lastly, we'd like to recognize Bullock Investigations. Their workforce is made up. Yes,
Commissioner, excuse me. We have David Olson, who is representing Capital Area.
Okay, so we'll go with David Olson, who's representing Capital Area on behalf of Tamara Atkinson. David?
Thank you, Commissioner. Workforce Solutions Capital Area is thankful to earn recognition for the 3rd year in a row for committing to hiring veterans with the We Hire Vets Award from the Texas Workforce Commission. As you mentioned, 11% of our employees are veterans. They served in the U.S. Army, the Navy, that'd be me, and the Marine Corps with a combined 19 years of service. For myself, I served for 5. In 2018, Workforce Solutions Capital Area became the first workforce board in the state of Texas to receive this recognition. We are honored to be awarded again. Supporting Texas veterans is part of our mission. Veterans receive priority for job and training referrals at Workforce Solutions Capital Area's 3 career centers across Austin. Career specialists at the centers are specially trained to help veterans of the U.S. military achieve maximum employment and training opportunities. We also participate in hiring Red, White, and You, an annual statewide event hosted by TWC. This year, we partnered with 4 of our neighboring workforce boards to host 5 unique virtual hiring experiences for Texans who served. Hiring Red, White, and You is today. Those job fairs are happening right now. To see what's going on in Central Texas, please visit warriorwelcome.com. Thank you, Commissioner.
David, thank you so much. And tell Tamara we appreciate all that she does and all that you guys do. And congratulations on it. And thank you for your service in the Navy as well. And so phenomenal with the job fairs that you're doing, the things that you're doing to take care of business in that regard. It means a lot to our veterans, and we appreciate all that you're doing in that regard. And then lastly, we'd like to recognize Bullock Investigations. Their workforce is made up of 47.75% veterans. And here to accept the recognition on their behalf is Master Sergeant Jack Lanier. We'd ask Master Sergeant Jack Lanier to have brief remarks, please. If Master Sergeant Lanier is not on the line, Bob, do you want to accept on behalf of Bullock Investigations?
Yes, Commissioner, I'll accept on behalf of Bullock Investigations. I know they're a veteran-owned company, small company. They're doing a tremendous job. And as they grow, they're going to look at hiring more veterans to increase their percentage in their workforce. Yeah.
47.75 is not bad. So we appreciate all that they're doing and appreciate the work from Bullock Investigations. And go again, thank you for your support in hiring our Texas veterans. Thank you for allowing us a brief moment to recognize those veterans. We have November the 11th coming up, and we just are so appreciative and thankful for our heroes in uniform. And so if you're listening and you think you might qualify for this program, again, go to www.texasoperationwelcomehome.com. Again, texasoperationwelcomehome.com in regards to hiring veterans. Before I turn this back over to our team, a few housekeeping items that I want to go over before we get started. If you experience any technical difficulties during the sessions, don't stress about that. We'll be recording this session and we'll have it available on our website for you to view and to share. CLE credit will not be available for these virtual sessions. Once we start back to in-person conferences, those credits will be offered as usual. And finally, sit back, relax, and enjoy these presentations. Our office is here for you, and we'll continue to be an essential resource as we move forward during these unprecedented times. Thank you again for your participation today, and let's continue to make progress. Now I'll turn it over to Attorney Velisa Chapa. So Velisa, go ahead and take it away.
Hello, everyone. As Commissioner Demerson said, my name is Velisa Chapa, and I'm one of the attorneys in his office, in the Commissioner Employer's Office at the Texas Workforce Commission. Very excited for today's information. A few housekeeping items. So you're going to be hearing a lot from the attorneys today, and I needed to make clear that the information we're providing is not legal advice, but it is legal information and guidance to the best of our knowledge. So we just wanted to point that out since we cannot take the place of a private attorney. Also, on this presentation, we've been doing a lot of COVID in the last several lunchtime live sessions. Today, we'll also have some COVID-19 information, but we're focusing a lot on policies and procedures in this presentation. So when COVID-19 becomes relevant, I am going to mention it, but a lot of these slides actually don't require a lot of COVID-19 change. So let's go ahead and dive right into today's presentation. We have a lot to cover in the next several minutes. So policies and procedures, I just want to make clear there's no law that requires you to have a policy. The law does not require that, but it's a really good idea to have policies. For one, they do act as a sword and a shield in a lawsuit. It can justify actions, and it can actually act as an affirmative defense in a lawsuit. And I will cover that in more specificity later on. They're also really important for unemployment claims. If you've dealt with one, you probably already know. If you don't have a policy or a policy acknowledgement form on the issue for why you let someone go, you might lose the claim. So policies are really important for that. The general idea is at TWC, we do not substitute our opinions for that of the employer. So what the employer says is acceptable or unacceptable is what really needs to be communicated to the agency. And finally, obviously, policies are really important to help maintain order. So there's a lot of good reasons why you want to have policies. Now there's a lot of concern too about how you kind of build from the ground up. Where do you start? This is my favorite checklist. I am a checklist person. And this particular slide, I think, is a good idea for folks to even print and keep. It's from top to bottom, start to finish, how you create a handbook and what you need to do. And the last piece talks about updating or changing when necessary. My recommendation would be to update your handbook or check it at least once a year to make sure that everything's good. A yearly review, I think, is a good idea for your handbook. So where to start, especially with COVID-19? There are so many possibilities out there. In my opinion, these are some of the most important policies that I think employers need right now in the time of COVID-19. Harassment is really important. There's a grievance procedure that I think employers need to have. And there's also a lot of concern and question about doctor's notes and people calling in sick and what do employers do. So I think a lot of these policies are really helpful to employers in that respect, and we are going to break that down in just a few minutes. So before I go into the meat of the presentation, I really also wanted to give you all this information, our Texas Guidebook for Employers. So there's so much to think about when you're an employer that it can be really overwhelming. And what I want to let you know is that you are not alone. Our senior attorney in our office created a guidebook for employers, and there's a link to the index of our book that I'm just going to click on to show you what it looks like. This index covers all of Texas and federal employment laws, and it's excellent because at the top you can see A to Z. So if you click on the letter C, for example, you might have a question about child support. Well, there it is, or child labor, and it'll give you lots of information. So I really encourage you all to look at the index. Also, we have sample policies. in this guidebook that you might want to use for your business. Lots of them, here they are, so you don't have to start from scratch. There's a lot of help out there for you, so we want to make sure that you know about those resources. Now here's going to be the roadmap of the presentation. We're not going to spend a whole lot of time on parts 1 and 2. It doesn't take that long, but we are going to cover the format of a policy. You need to know that. Also enforcement and why that's important and how to do it. And in my opinion, the best practices for enforcing your policies the right way. And finally, we're going to talk about the actual laws on policies, different topics, what you have the authority to do as a Texas employer and what you don't. So let's start with creating your handbook. This is really basic. I know, explain the rule, right? Say what you mean. That's pretty understandable. But you also want to provide examples, and that is sometimes really important. And an example of that would be disrespectful conduct. We all have different viewpoints on when conduct becomes disrespectful, how much we're willing to put up with, what we think is appropriate. Some employers, cursing in the office is common. In other offices, it's not allowed, or it's considered disrespectful. Also, things like rolling your eyes, yelling at people, anything so that you might consider to be disrespectful. So it's important for employers to explain what those examples are. And the third part here is actually the biggest part I wanted to emphasize: consequences. That's a huge piece that I've noticed is missing in a lot of policies. You tell employees what the rules are, like attendance, for example, but you don't have consequences. And so each employer in Texas has the authority to define its own progressive disciplinary procedure. A lot of employers will do 3 strikes and you're out. Some employers will do 5 or 7. Some have done 20. It's completely up to the employer to decide how many warnings an employee should get before discharge. But in some cases, you might want a 0 tolerance policy. So I'm actually a fan of 0 tolerance policies, but the caution here is you really want to make sure that the policy, if it is 0 tolerance, that it's something within the employee's power to control completely. For example, fighting on the job. Another example would be smoking. So I talked about sample policies we had for you. Here's one of them. It's a smoking policy. Obviously, I'm not going to read this, but the point of this is to show you how extensive a policy can be when you're trying to give examples. And you can see the language at the top that talks about, cigarettes, pipes, cigars, snuff, tobacco. Gets very, very specific. Also at the bottom in all caps is where it says this is a 0 tolerance policy. If you violate it, you will be discharged. There is no hiding the ball. So with your 0 tolerance policies, if you want one, put the consequences at the bottom so employees will know what happens. And sexual harassment is a popular one, as is fighting on the job or violence. That is also very often a 0 tolerance policy for different businesses. So that's it for your policies. But let's talk about enforcement. That's the next part of the puzzle. And it really is not fun, but it is necessary. Enforcement to me is one of the most difficult parts of being an employer. Unless you're the Grinch, you're not going to enjoy it, but it is necessary, and here's why. If you don't enforce your policies, they lose their teeth. And so you spent all of this time making a policy that you're not enforcing. It's kind of all for naught. Not only that, you want to be very cautious with not enforcing your policies, because if you have wishy-washy enforcement within the company, that opens the door for someone to allege that they are being retaliated against, discriminated against because of a protected reason. So that's really common with companies that have multiple managers. They all have different styles. Someone's harsher than the other. It makes sense on the surface that people wouldn't be treated as equally as others based on the manager they have. That's a problem. The employer needs to be careful to make sure that all the managers are on the same page with how these policies are going to be enforced. Because if it looks like unequal enforcement, that is what opens the door. And the way I see it is each employer is standing in a room full of doors. Through each door is a lawsuit. So your goal is to keep that door shut and locked. And when you have unequal policy enforcement, you're unlocking the door and you're putting your hand on the handle and turning it. And that's what you want to avoid. So proper enforcement requires 3 really important pieces. You got to investigate. And if you confirm it, disciplinary action. And then you need to document everything while it's fresh in your mind. So we're going to cover those 3 pieces in just a moment. So starting with investigations, you are the Sherlock Holmes. You're putting on that hat when you have to investigate. Whenever you get a complaint, whether coworker to coworker, employee is upset with the manager or the owner, if there's a complaint, if there's an issue, the employer is required to investigate. And it's not necessarily required by law, but if you want to keep those lawsuit doors shut, you need to investigate, you need to document it, you need to make sure that if you're going to discipline someone or reach a conclusion, that you have the documentation to back it up. You need the receipts. So when it comes to investigations, you want to investigate before you warn someone, right? You want to know that the warning is justified. Also, if you don't investigate, what you're essentially doing is relying upon the word of whoever complained, and that can get employers in a lot of trouble because you want to trust that individual, but memories can fail, people can deceive, things can happen. So whenever you're hanging your hat on the word of someone else and not investigating, you're putting the company in danger as well as yourself. So it's really important to, even though it's tempting to stick with one side or the other because you've known them, you have to do your due diligence. Another piece that's often forgotten is employers will not question the accused. I see that a lot in unemployment claims, especially. They'll say, well, no, we saw the video, we know what happened. That makes complete sense. But from an investigative standpoint, you do want to question the accused, get their side of the story, have them write their statement down, because again, your investigation needs to be complete. So it adds that additional piece, and getting that statement from that accused person allows you to see if there are any additional holes, pockets, issues that maybe you didn't notice initially. Also, you have to be discreet. It can be very tempting to discuss these investigations as information develops, but you have to keep it confidential. But as far as the person who complained, here's a tip. You don't want to keep them in the dark. Sometimes investigations last a few days. Sometimes they last weeks, and the person who complained is wringing their hands, wondering what's going to happen. So if that happens, you want to keep them updated. And it could be something as simple as, hey, we haven't forgotten about you. We are still looking into it. We will keep you updated, to let them know that you're still on it, that you care, that you haven't, swept it under the rug or put it on the back burner. I think that's important. Also, unpaid suspensions. I wanted to bring this point across. It's very common for employers to place employees on unpaid suspensions when they're investigating. There's no law against it, but here's the trick. If you care about an unemployment claim, stick to 3 days or less if possible. And this is about unpaid suspension. And here's the reason why. The morning of day 4, they have been discharged for purposes of unemployment. And then you'd have to prove that you fired them for misconduct, which can be difficult sometimes because you weren't intending to discharge them. You were just trying to investigate and kind of get the employee out of there while you're doing that, which is fine. But the point is, if it's more than 3 days of unpaid suspension, they have been discharged for purposes of an unemployment claim. The other thing you want to avoid is indefinite suspensions. It's like, well, get out of here. We're going to look into this. We'll call you back when we know more. Technically, for unemployment, you laid them off right there in that moment, because the idea is they don't know when they're going to come back to work again. They don't know when their next shift is. So when it comes to suspensions, do not do indefinite suspensions. And if you are doing an unpaid suspension, 3 days or less. Now, this is a really interesting note that we got from an unemployment claim that we were looking at, actually. So there's a difficult story behind this. And this has to do with investigations. An employee requested time off to visit his 8-year-old son, who had allegedly been shot to death. Horrible set of circumstances. So the employer gave him time off to travel out of state and take care of his family. The employee never returned. But there was a lot of back and forth with a doctor's note and with this document you see in front of you. In order to verify the need for the absence, the employee gave this document to the employer. And as you can see, I've underlined some pieces that have some suspicious language. Instead of long live, it says long love, just some misspellings and things that didn't look right. So the employer investigated and looked up the name of this child online, And it just so happens that there was an individual by this name, unfortunately, who did lose his life, but that happened 2 years before this employee said it happened. And it was a very high profile case on the internet, so it didn't take long for the employer to find out that this note was not true. This happened years ago, and this employee was in no way related to this individual. So after discovering this, the employer was able to provide it for the unemployment claim and show that the reason for leave was not justified, that the individual was attempting to deceive the employer. So that's why investigations are important. Obviously, sometimes it's not so obvious, but it is important to look into that if you deem appropriate and document it, and of course, be discreet. So let's talk about warnings. It's the next piece. You've investigated, it happened, you're issuing the warning. How do you do it? This, to me, is one of the most important slides of the presentation because the points are so basic but so important. Number one, you want 2 first-hand witnesses present if you can for a warning. You, the employee, and someone else with authority, you know, another manager, a supervisor, it could even be a spouse, never a coworker, because embarrassing warnings don't stick. That's why you never warn someone in public and you never warn someone in front of a coworker. You have to be discreet. But the idea is ideally 2 first-hand witnesses, 3 people in the room every time. And that the reason for that is that sometimes an employee will deny signing something, will deny the warning. And so you want 2 witnesses to verify that that is not correct. Also, you want warnings in writing. Tons of employers will have a disciplinary procedure that says, all right, we'll do some verbal warnings and then some written warnings and go from there. Like my colleague says, if it's not written down, it didn't happen. And that's important. Written warnings are crucial. I see lots of cases where the employer will say, well, we gave him verbal warnings. When? Oh, I don't know, a few months ago. That's really not going to be very credible. And even if you do have specific dates of the warning, how do you prove it? It wasn't written down. It's going to be your word against theirs. And even if it is a written warning and it's one-on-one and they sign it, they can turn around later and say that you forged their signature. That's why a 3rd witness is important for that. And the purpose of a warning, remember, is not to have the employee sign it and admit to the wrongdoing. Oftentimes, that's not what happens. But the purpose of them signing the warning is to prove that they got the warning. That's the idea. Also, you don't want to delay. It's really common, especially during the holidays. It's November, Thanksgiving, Christmas time. You don't want to delay. It can be tempting to say, well, it's the holidays, I don't want to do it now. The problem with that is if you delay, it's going to go further and further. And if you let them go, for one, winning the unemployment claim is going to be difficult because there was a delay, which would suggest that it wasn't so serious as to constitute misconduct, right? Whatever it was that they did that led to your decision to let them go. Also, it looks suspicious. Sometimes employees can say, well, you didn't fire me because of this poor performance. Really, you discovered my religion. I'm now over the age of 65 and you want to get me out of here. So that raises issues. And I think it's best for employers to not delay when those issues come up. Also, realistically, sometimes you don't know the policy was violated until recently. That's different. If you just discovered it, then you couldn't have warned them earlier. You didn't know. So there are exceptions to that rule. Okay, final warning. Final means final, folks. There's lots of employers who will give multiple final warnings, and it tends to lose its oomph when you do that. Also, a final warning means final. There's a lot of final warnings that say, further violation will result in disciplinary action up to and including termination. It's okay to have that language, but when it's a final warning, the idea is if you do this again, you're done. So having that language of we're going to take some action up to and including, that suggests you might warn them, but that's not where you're at. You're at the point where you're going to let them go if it happens again. Also, determine the scope of the final warning. Some employers will say, if you break this rule again, you're fired. Others will say, if you break this or any other rule again, you're done. So you can choose the scope of the warning and make sure that that's clear. Sometimes they get a final warning for attendance, And then the next day, they, let's say they violate another rule for, an excessive break or something like that. Or maybe they disrespect someone in the lobby or whatever it may be. You want to make sure that they know that if they're on thin ice, that it counts for everything, if that's what you want to tell them. And we do have a sample warning that you can click on the bottom of this slide. And these slides should, upon request, should be available for folks to look at. So documentation, I know I've mentioned it before, but it really is everything. It's important to refresh witnesses' memories, and it's important that the documentation is done close in time to the incident, because you forget a lot of facts overnight. So my tip is that when someone needs to write something down, they need to write it in their own words. Don't write it for them, because then it's going to be in your language. It's going to look like you influenced it. So when someone asks, well, what do I write? The who, what, when, where, and how. So let's go into part 3. The rest of the presentation is going to be about policies and COVID and how, what you can do and what you can't. So let's start with employee breaks. There's a huge misconception on this law. Here's the deal. Generally, breaks are not required by law, which sounds odd, doesn't it? There are some exceptions. Nursing mothers and employees with disabilities might need breaks. Not only that, there are some city ordinances for construction that might require breaks. For example, San Antonio has a city ordinance where if you're working in construction, 2 10-minute breaks a day, which is important. Of course, they're working a dangerous job at high altitudes, a lot going on. So look into your city ordinances to see if there's anything special there, but generally speaking, not required unless you're a nursing mother or an employee with a disability. But the twist is not allowing breaks can violate law. And as a real example, there is a very well-known chicken processing company in the United States, and they were not allowing employees to take bathroom breaks. So from what I understand with the complaint, folks were wearing adult diapers on the line because they didn't have time to use the restroom. They didn't have an opportunity to use a break. So that's an OSHA violation, potentially, an unsafe working environment. So it is a best practice to give employees breaks. Of course, we need them, and various studies show that frequent breaks actually help performance. Also, let's talk about paying. At what point do you have to pay them for a break? If it's a lunch break of 30 minutes or more, you don't have to pay. If it's under 30 minutes, pay. So what if they don't take their lunch break and they were supposed to, and it's 30 minutes or more? You have to pay them, but that could turn into a policy violation if they didn't take their required break. And also, employees may clock in and out for all their breaks. Big key, the last point, they should be allowed to use their cell phones. There's a big reason for that under the National Labor Relations Act and the ability to discuss workplace conditions. So allow employees to use their cell phones during breaks. Now let's talk about harassment. This has been a big issue in the media, but I want to talk about what it means for employers, what it actually means. So harassment, it's unwelcome conduct, and it's based on a protected class characteristic, race, color, religion, sex, age, disability. So that's what it's about. If what I've heard about is what I call an equal opportunity screamer, the owner who yells at everyone. That's intolerable, but not harassment because it's not connected to a protected class. Everyone's getting mistreated in that scenario. So where does harassment become unlawful? When enduring it becomes a condition of employment, or when the conduct is severe enough to create a work environment that a reasonable person would consider to be intimidating or hostile. And I did have an experience like that years ago when I worked for a law firm. I was harassed, quite honestly, on several of these factors, and I felt very uncomfortable, and like I would not get a raise, if I didn't play ball. And I was very young, so I didn't know any better. But this happens all the time. The key here too is if it's a petty or a slight annoyance, that's not going to go to harassment. And the easiest example I can think of is, let's think about sexual harassment. We all have our own bubbles. We're all comfortable in our own way. And so if someone touches you on the shoulder, it might make you very uncomfortable, and you might consider it to be, harassment. I don't want this, which we are looking at it through the eyes of the alleged victim. So if you're uncomfortable with it, that needs to be addressed. But a touch on the shoulder, is not, it's a slight annoyance. It's an isolated incident. It doesn't rise to the level of harassment, but it is still something the employer should address. There's been other harassment where, people are touched in inappropriate places. That's a little bit different. So there can be a fine line, but it's one of those things where you know it when you see it. But isolated incidents do not count, but they should be addressed and corrected. So here are the dangers of harassment. If it's happening, what can then happen is if the manager is harassing an employee, and then later on that employee gets a warning or demoted or something, all of these lawsuit doors get opened. Discrimination, retaliation, intentional infliction of emotional distress, it goes on and on. So what you'd want to start with policy-wise is a harassment and disrespect towards others policy. And so we have a sample one for you. It's not print ready, of course. You can see it has XYZ company, but this is a really good starting point for employers to see how a harassment policy should look. Now, how does this apply to the workplace specifically? This is really important for everyone to know. So what if it's a supervisor harassing someone they have actual or perceived control over? The employer is automatically liable. Automatic liability. There is no saving grace of, oh, we didn't know about it. If it's a manager harassing someone they have any control over, the employer is automatically liable. It's too late. So that's why the employer really wants to stay on top of that. Also, what if it's not the manager? What if it's employee to employee? Or what if it's customer to employee? That happens a lot too. Lots of home health agencies, they've called with issues about that. The employer is liable if you knew about it and failed to take corrective action. So there's a little more breathing room here, but again, it still needs to be addressed. So how do you address all of it? Have a policy. Educate and train, especially your supervisors. And here's another tip. Think about limiting your supervisor's authority to negatively affect employees' status with the company. And what I mean by that is the supervisor could make a recommendation. Let's say it's a demotion or a pay cut or a warning. A lot of employers will have a 3-check process. Before you move forward with the supervisor's recommendation, it needs to be approved by 2 higher ups to make sure there's nothing beneath the surface that could suggest that this was an inappropriate warning or demotion or whatever they're going to do. So maybe consider that, having it approved by 2 higher ups before you move forward. And of course, act immediately, document, because you want to show that you're addressing everything as quickly as you can. Grievance procedure. It's a huge part of it. So the purpose of a grievance procedure is you want employees to know, first of all, if you have a complaint, we have a way for you to address it. We want you to come to us, let's talk. It also acts as an affirmative defense in a lawsuit. Think of it like if there's 4 people they have to go to and they skip that and go straight to the owner. If the person in the middle didn't know about it, there's nothing really to correct. So it's helpful in that sense. Here's the key. In many policies, if an employee violates it, you discipline them. Do not do that with a grievance procedure. Every employer can develop a procedure that works for them. The key is never punish an employee for skipping steps in that procedure. That's not the point. That can get you in trouble. Again, the point is for them to have an avenue to go down if they have a complaint, but you never discipline an employee if they don't go and take those exact steps. That's not the point. Let's talk about absenteeism. This is happening a lot in times of COVID-19. There's lots of issues going on. So let's start with the basics. As an employer, generally, you have the authority to decide how many tardies or absences you'll allow, how they need to tell you, do they text, email, or call, within how much time do they tell you, who do they tell, their manager, the supervisor, HR. So you decide all of those rules, and there are exceptions which happen in life. So if there is an exception, you want to make a note of that and put it in the employee's file. So during COVID-19, here's the twist. You should be considering flexible leave policies for your employees. Remote work, of course, is also recommended, documenting everything. The Department of Labor has a lot of helpful information on attendance in COVID-19 as well, just with what you can ask and how things go. So here's the link. Tons of questions. So it's on there as well, and I do think it's worth looking at because there are some questions that come up, and here's one of them. What if an employee, you want an employee to quarantine? They don't ask for it, but you want it. Can you require that? Well, generally, yes, under these conditions. First of all, if you know the employee was exposed to COVID-19, and it doesn't matter if, if it happened on the weekend with their family at a picnic. If they were exposed because of their personal activities, you have the authority to send them home for safety reasons. Safety overrides pretty much everything right now. Second, sometimes you can discover that the employee wasn't practicing safety measures. Social media is a big way that employers are finding that out. Quick tip, in my opinion, an employer policy should be not to be social media friends with your employees. I think you need to keep the two worlds separate. And the shortest answer as to why is because the more you know, the more danger there is that an employee could allege that you're treating them differently for other reasons, like if you find out through Facebook what their religion is, or finding out that one of their family members has cancer and now you're treating them differently because of it, or they feel that you are. So it kind of opens this can of worms that you probably want to keep shut. But if a coworker or someone brings you a social media, hey, here's so-and-so who said she was really sick, but here, or she was great and she's doing cartwheels at the beach and she's around all these people, well, that's going to be something that the employer can address and get a screenshot of that photo. Also, tips and complaints. Some folks have multiple jobs, and I spoke to an employer where it was a small town, and this person worked at a fast food restaurant as well as with the employer. And the fast food restaurant manager called the employer and said, hey, just so that you know, so-and-so has been talking here about how she was exposed and she doesn't care and she's not really trying anything. So we sent her home, but we think you should know that too. So sometimes you get information about that tells you, you know what, we need to be safe. Also, if they're engaging in personal travel, that's something the employer might want to look at as well. And remote work, in my opinion, should be something the employers should explore because that is going to be more of the norm as time moves on. Recording time worked. The point of this slide is to just let everyone know, in my opinion, I think all employees can be clocking in and out. There's different reasons for it. I'm salaried exempt. I don't get overtime. If I did, I'd be a millionaire, as I say. But I can still be clocking in and out because I was hired to serve you 8 to 5 Monday through Friday. And I'm sure my boss would want to know that I am serving you during that time. Showing up at 10 and leaving at 4 is not going to work. So there's different motivations for recording work time, and attorneys differ on this. In my opinion, I think you could require all employees to record their time. Now, vacation and sick leave. I'm going to break it down one after the other. Vacation leave. Do you have to give it? Not required by law. It can be paid or unpaid. You decide. Everything is the employer. How much they get, does it roll over from year to year? How do they request it? All of that good stuff. Now here's the deal. If you have your vacation leave policy, it's enforceable. If it's in writing, it's basically become a mini law and you have to enforce it. You're bound to pay according to those terms. Now here's an update for sick leave. Sick leave's a little bit different. There's a COVID-19 update, the Families First Coronavirus Response Act. I did a webinar on this a few weeks ago, so there's a lot of good information there. This law expires December 31st, but this is the first law, I believe, in US history that requires employers to pay employees sick leave for illness, but this is specifically tied to COVID-19 and childcare issues. So take a look at that link from the Department of Labor. Take a look at our prior webinar for more information on that. As far as the general rules for sick leave before COVID-19, what about your own internal policies? Well, paid sick leave has never been required, but if it's in your company policy, it is enforceable by law. Unpaid leave, generally not required, but there are exceptions for sick unpaid leave. If they have a protected disability under the Americans with Disabilities Act or the Family Medical Leave Act, That is protected leave. It doesn't have to be paid, but you do have to give them that. And it goes without saying, you never count those absences against an employee on their attendance total, because again, that looks like you're punishing them for their disability. Now, PTO balances, what if they separate from you and they have a balance? Do you have to pay it out? No, unless your policy or past practice says so. So you could have a use it or lose it, but you do want to make it clear. Let's talk about doctor's notes. There's been some COVID changes. Can you ask for a doctor's note? Yes. Here's what you don't ask for: diagnosis or prognosis. You don't need to know what their condition is. It's really not your business. What you need to know is what accommodations you need to make in the office to assist them while they are dealing with that issue. Now, here's a little twist. Normally, you cannot be asking people what they're sick with, but because of COVID-19, according to the EEOC, you can ask them if they're having symptoms of the pandemic virus. So you are allowed to do that currently. With doctor's notes, you do want to give them a deadline. And if you're trying to figure out what they can do, what they can't do, you want to give them a job description to give to the doctor so the doctor knows exactly what they do for their job. And so with that, you want to know what day they're coming back. Are they released to full duty? Are they going to have some restrictions? If so, what are they and how long will those last? It's all about keeping the trains running on time. And to do that, you don't need to know what their medical condition is. So if you think about it like that, it should be easier to handle. So the COVID-19 update, it's difficult sometimes for folks to get standard fitness for duty letters because of the pandemic. So there are acceptable alternatives. Emails tend to be very popular to certify a negative result from a local clinic. So do keep that in mind while we're in this new world of COVID-19. So I talked earlier about that employee who falsified a letter about his child who apparently passed away. This is another document that he submitted. And as you can see, it's a little suspicious because the font sizes are different. It's a little odd that it says work or school, considering that this individual was not in school. So this was another suspicious document the employer looked into. Verifying doctor's notes is something you may have to do. There are a lot of fake doctor's note websites online, so you need to look for suspicious items in the note. That's going to be important now. And this is not a COVID-19 problem necessarily. This has been happening for years, but I think that it has gotten more aggressive in light of COVID-19. So where do you start? You can call the facility and see if it actually exists. See if the doctor works at that facility. Sometimes it's all you need, but verifying those notes, I think, is something the employer has the authority to do, especially if you think it looks suspicious. Let's talk about social media and the internet. So monitoring computer usage. In COVID-19, there's a lot of remote work and a lot of folks are using company issued equipment. Here's the key for you employers. Whatever they do on company computers is not automatically yours to look at. For example, if they're using the company laptop to write a letter to their doctor, you don't have the right to look at it just because it's on your equipment. So you can monitor computer usage, but you have to know not to get in the way of an employee's privacy rights. So there is a sample media policy here and computer usage policy. I highly encourage folks to look at it. So what if you see things on social media? I talked about this a little bit ago. Can you take action against something you see someone do on social media? Well, yes, if it damages company business or work relationships, you can. A common one is drug use. A lot of folks are not criminal masterminds and they'll put pictures of themselves partaking in a substance. Crime, company policy violations, and here's a real example. A former nurse tweeted that she was sleepy in the ICU and was asking for someone to code and give her something exciting to do. A very insensitive comment. The employer saw it and let her go. So you can take action for those kinds of things. Let's talk about COVID-19 mask policy, another hot topic. You may require employees and others to wear masks. If they refuse for personal reasons, as they just don't believe in them, that's not protected. That's personal preference is not protected by law, but medical conditions are. So if an employee refuses to use a mask for medical reasons, please consider reasonable accommodation under the Americans with Disabilities Act. You may need to accommodate them if that is the case. Can you ask for medical documentation? You can to verify the need for the use of the mask in general. Again, you don't want to ask about the underlying issue. It is not your business. And you can explore alternative accommodations, sometimes remote work or modifying schedules so that less people are in the office. So it's really going to be the time for us to be creative to see how we can work with folks. Now, what if employees are wearing masks with controversial logos or language? Here's an idea: only require blank colored masks. Or you can even order masks with your company logo and ask your employees to wear that as part of their uniform policy. So that is also something to consider. So if you want to know about temperature and health screen policy, Mario Hernandez is going to be talking about this in just a few short minutes to give you more information on how to do this in compliance with federal law. Also, teleworking. You want to know, how do we work with teleworking? What policies? What's the good and bad? Tune in November 19th. Elsa Ramos is going to be discussing this, and she is going to share a lot of good information on that. So quick prohibited policies. Avoid these policies. Never prevent employees from discussing their pay with one another. That's a violation of the National Labor Relations Act, which is a federal law. Employees have the right to discuss their pay with one another. Also, it's tempting when someone has property to hold on to their final paycheck before they deliver the property back. You cannot do that. Their obligation to return company property is separate and apart from your obligation to pay them on time. Finally, never have an employee sign something where they promise not to file a claim with Texas Workforce. You can do up to 6 months in jail for that and get fined. So they always have the right to file an unemployment claim. So avoid those 3 policies. Distributing your handbook, the main point of this slide is just to let you all know that sometimes your employees, English is not the primary language. You want to make sure your employees understand your handbook. So for that, you might want to have someone there to translate. That might be the way to go, and maybe ask the employee if they have someone they'd like to take on that role. Also, make sure it's accessible to all employees. Do you have to give a copy of your handbook to everyone? No, especially if you write it, it's copyrighted, you know, it's your work. So a lot of employers don't want to share a copy of their handbook with everyone. They've worked hard on it. That's all right. The key is you want to make sure the policy handbook is accessible to employees when they want it or need it. That's the key. So they don't have to have their own separate copies, but it just needs to be accessible. Acknowledgement form. This is huge. Once they read the handbook, they need to sign the policy acknowledging the handbook. Everyone should sign it. If you update your policies, have them sign an updated acknowledgement. What about e-signatures? Super popular these days. E-signatures are generally okay. You just want to make sure that it's password protected and you have the controls in place to prove that they are the person who signed it. They're the only one with the password. And we have a sample form for you as well. Changing and updating. Here's how you do it. You let people know in advance you're going to make some changes. Like today's Thursday. Tomorrow we're going to talk about our new attendance policy. Train them and have them sign a new document form to show that they understand the policies. You know, letting them know the old way is gone, we're going to this new way, and here's how it is. And then they can have time to ask questions and all that good stuff. So that's it for my presentation today. I thank you so much for your attention. This was a very important topic, I think, for a lot of folks to know about. So I am so glad that I could provide it to you. And the next speaker that we have on today's docket is going to be Mario Hernandez. And as I stated, he's going to talk about a lot of useful information on workplace health screens and medical exams. So I will turn it over to Mario.
Thank you, Melissa. I appreciate the very kind introduction. As Melissa mentioned, my name is Mario Hernandez, and I'll be talking to you today about the topic of workplace health screens and medical exams. And before I do so, I just want to give just a moment of thanks for the participants and the presenters in today's lunchtime live session. Thank you all so much for your contributions and information. Really appreciate that. And with that in mind, let's talk a little bit now about workplace health screens and medical exams. Now, the first thing is to keep some helpful information in mind as we proceed through this particular topic. And the first thing to keep in mind is that guidance changes. Again, guidance changes. As we learn more about the virus and COVID-19, some guidance from agencies or healthcare professionals might get modified, it might get changed. So it is very important as an employer to keep up to date with relevant agency resources of information related to the virus, related to COVID-19. That way you can keep on top of the most up-to-date information. And another thing to keep in mind is to have a plan and follow it, especially with things like workplace health screenings and medical exams. You don't want to just kind of rush into it or go into it without any kind of planning. A good plan and groundwork will be essential in making sure that you have an effective policy for these types of items, and update your company procedures as necessary. Ms. Chapa spoke about that in her previous presentation. So just to give you a bit of information on the resources that will be involved in this particular presentation, there's two big main ones. And the first is the U.S. Equal Employment Opportunity Commission, the EEOC, and the Centers for Disease Control and Prevention, the CDC. And the upcoming topics by way of a roadmap, we'll talk a little bit about temperature checks, screening questions, and pre-employment considerations. Up first is temperature checks. Now, we have gotten quite a few questions about temperature checks, and the reason that the EEOC is mentioned is that they play a really big role in this type of analysis for employment law related situations, specifically through enforcement of the Americans with Disabilities Act, the ADA. The ADA has restrictions on when and how much medical information an employer may obtain from an applicant or an employee. And so once an employee begins work, any disability related inquiries or medical exams must be job related and consistent with business necessity. Now, per the EEOC, generally measuring an employee's body temperature is a medical examination. But because the CDC and the state local health authorities have acknowledged community spread of COVID-19 and issued attendant precautions, employers may measure employees' body temperature. And by the way, ladies and gentlemen, just by way of giving you a little bit of kind of clarification here, you may notice a symbol, kind of at the top of the page in the heading. That symbol relates to a link that will be available in a source legend slide at the end of my presentation that will have the website where this information is gathered from. So I definitely encourage you to visit those resources when we get to that particular slide, but just so that you can kind of follow along and know what those symbols mean. Now, going forward, asking only one employee to take a temperature check is restricted per the EEOC. In this kind of situation, if the employer wishes to only ask a particular employee, like, hey, could you take a temperature check? The only way that that really can happen is that the ADA requires the employer to have a reasonable belief based on objective evidence that this person might have the disease. Again, so there's restrictions on if you're just going to do it for one person and not for all. So again, per the EEOC, you'll want to make sure that you're aware of that if that's something that you're considering doing. And of course, information related to temperature checks is absolutely confidential. The ADA requires that all medical information about a particular employee be stored separately from the employee's personnel file, and thus limiting the access to that kind of confidential information. It should be in its own separate confidential medical file. And that would include information about the temperature checks and whether or not the worker has disclosed that they have symptoms or that they suspect that they have the disease and so forth. Some employers have even asked, can we take a log of the temperature checks that we are considering doing at our workplace? And per the EEOC, yes, the employer can take a log of the temperatures, but again, that log is to maintain confidentiality. You have to maintain the confidential nature of those things because it is confidential information, so the employer needs to ensure that that happens. So when we talk about temperature checks and the EEOC, that's on the employment law, the employment law analysis side of things. The flip side of it, is safety in executing that kind of policy. And that's where we turn to the CDC. And for temperature checks related to CDC, of the utmost importance is the protection of the screeners themselves. Obviously, when the employer is considering doing temperature checks, they'll have to identify somebody who's going to be performing them. And so the CDC has really good information about measures to take to kind of mitigate safety issues to those screeners, things on social distancing, perhaps reliance on barriers and partition controls, those sort of mechanisms. And again, as noted before, you can review this information at the link in the source legend that will be at the end of this presentation, and the specific place where you can find it on the link in the source legend is on the slide right here before you. It should be pretty straightforward to follow in terms of getting to the info. And the CDC also has separate guidance for healthcare settings. And this is just as good an opportunity as any to inform our listeners today that depending on the type of industry that you're in, there may be different regulations, different rules, different protocols. So definitely make sure that you're keeping aware of that too. Going from temperature checks and now going to screening questions, like what kind of things can you ask employees related to COVID-19? Per the EEOC, the employer may ask all employees who will be physically entering the workplace, key phrase there, if they have COVID-19 or symptoms associated with COVID-19, and ask if they have been tested for COVID-19. However, employers, the next point, may not ask an employee who is physically coming into the workplace whether they have family members who have COVID-19 or symptoms associated with COVID-19. And that's because the Genetic Information Non-Discrimination Act, GINA, prohibits employers from asking employees medical questions about family members. So keep that in mind when you're considering asking screening questions about COVID-19 symptoms and COVID-19 related health items. Again, the flip side of things, the CDC guidance, COVID-19 questions. Again, this looks very similar from the CDC guidance talking about temperature checks. Again, protection of screeners of utmost importance. And the CDC also has really good guidance about screening questions, things that you can think about when asking workers. Consider including, they have things about including certain symptoms that you can ask for, fever or feeling feverish, new cough, difficult breathing, sore throat, and so on. So the employer will definitely want to take a look at those particular resources. Now, going away from the screening questions and talking about COVID-19 tests themselves. Now, the information on COVID-19 tests is extensive, and I feel like going into that particular topic in detail would not allow it the full attention that it deserves, but I'm not going to let the employer empty-handed because I do have some good startup links for you that you can visit about COVID-19's tests specifically. The EEOC has good information about it, and the CDC has really good information about it as well, and you can visit that information in the links provided to you in this slide right here. Also make note that the CDC in that link also has the words of non-healthcare workplaces, testing non-healthcare workplaces. So if you're in a healthcare workplace, I believe the CDC has specific guidance for your particular industry. So make sure that you're aware of that. A little more EEOC guidance in terms of workplace health screens and medical exams as it pertains to pre-employment. There's a really good section about information regarding hiring and onboarding in the EEOC link that's in the source legend. I definitely recommend you to look at that during this time. If you're hiring individuals, information like, can an employer screen job applicants for symptoms of COVID-19? The answer is yes, they can. An employer may screen job applicants for symptoms of COVID-19 after making a conditional job offer, as long as it does so for all entering employees in the same type of job. So that's something that an employer may do. A little more on EEOC guidance. There's also information about returning to work as restrictions get lifted, stay-at-home restrictions get lifted. As we learn more about the COVID-19 virus and so forth, there may be modifications in certain, like I mentioned, restrictions being lifted. So the EEOC has guidance about that on returning to work. Take a look at that for sure. And the other thing I'd be, definitely have to mention reasonable accommodation when you talk about the Americans with Disabilities Act or the Rehabilitation Act, because you may encounter a situation where a worker requests an alternative method of screening due to a medical condition. And per the EEOC, that's a request for reasonable accommodation, and an employer should proceed as it would for any other request for accommodation under the ADA or the Rehabilitation Act. And also keep in mind too, ladies and gentlemen, that if an employee requested an alternative method of screening due to a religious accommodation, that could also be a request for reasonable accommodation under Title VII of the Civil Rights Act. So definitely keep those concepts in mind when you're thinking about or considering adopting screening measures at the workplace. Again, can't stress enough to visit the EEOC guidance for yourself to make sure that you view it for context, because there's definitely more information out there. Some additional resources separate from the ones that we've talked about. We've got state guidance and we've got local guidance. As far as state guidance is concerned, you can visit the Office of the Texas Governor's website. That's right there, gov.texas.gov, to get up to date on executive orders. And also on that page is the Governor's Strike Force to Open Texas. And that website is at the bottom of the slide, open.texas.gov. And the Governor's Strike Force to Open Texas, per their website, will safely and strategically restart and revitalize all aspects of the Lone Star State: work, school, entertainment, and culture. So that's something that you definitely want to keep a look at. They've got Open Texas checklists, minimum standard health protocols for all employers and event organizers and other specific industries. For example, the checklist for all employers and event organizers has information about screening and temperature checks under the category of health protocols for your employees and contractors. So definitely a state resource that you'll want to take a look at. For other state guidance, you can visit the Texas Department of State and Health Services. Two of their really prime links for coronavirus related material are at the links that you see right there. And I'll just give you a moment to really take a look at that. And that's the state guidance. And moving on to local guidance, depending on your location in the state, local authorities may have different rules and regulations for that location. So county and city officials are really good resources of local information for those locations, for the respective locations. So definitely do not hesitate, calling, your local city hall or your county seat to get up-to-date information about the latest COVID-19 protocols and procedures. That'll definitely help guide you in making educated decisions. Okay, so some takeaways from what we've talked about in this particular presentation. The first is gather resource information. The other thing I have to stress here too, ladies and gentlemen, is that the information that you see in this presentation is by no means exhaustive. You are definitely encouraged and should do your research to make sure that you're gathering the most information you can related to policies and procedures, especially when dealing with workplace health screens and medical exams. That way you can make informed and educated decisions about those particular items. So definitely do your due diligence in gathering your resource information, because there's a lot out there, a lot that wasn't able to be covered in this presentation. Just off the top of my head, OSHA, is a big agency out there, and I didn't even get to mention them. So again, just a lot of information out there. So make sure that you're doing your due diligence in gathering it. Establish and implement a plan for safety protocols at the workplace. We've talked about that already. Keep up to date with changes in guidance. Kind of goes back to that first kind of couple of slides where you got to keep up to date because things can change. What may be the case today might not be the case tomorrow. So you got to really keep up to date with that. Update policies and procedures as necessary. And of course, you're definitely encouraged to consider hiring legal counsel for complex situations. And now is a good time to mention that this presentation is not legal advice, but it's definitely a presentation of information that the employers can use as a starting point to get more familiar about topics related to workplace health screens and medical exams. But as you gather that information, you might encounter a situation or two where information might appear to conflict with each other. And so in those particular situations, especially with dealing with sensitive topics like workplace health screens and medical exams, it's all the more reason to consider hiring legal counsel to guide you through those particular issues, if not to help you navigate through them, and also to clue you in, perhaps to make sure that an important issue is not missed. Okay, seem to have been disconnected temporarily there. Let's see here.
You're back now, Mario.
Okay,
Mario,
really quickly, let me see if I can pop back up here. Unexpected technical difficulty there. Okay. The good news is that I was at the end of my presentation. So as promised, here's the source legend, and you can take a look at the links, as I mentioned before, for all the information provided in the talk today. So without further ado, thank you all for your very kind attention. I'm going to go ahead and stop sharing my screen, and I'm going to now turn the proceedings over to Tommy Simmons, who will be talking about Payroll Tax 101. Take it away, Tommy.
Tommy, you may be
Tommy, you're
muted.
muted.
Okay, can everybody see my slides?
Yes.
Payroll Tax 101. Very
Yes.
good. Okay, on this, I'd like to call attention to the contact information. If you have questions, you can send them to the email address shown on that slide, employerinfo@twc.texas.gov. And then we have a frequently asked questions file for these lunchtime live sessions that we maintain on our website at that address. And there is a link from the table of contents of the book and also from the events page on our website as well to find this. Our online book for employers, the Texas Guidebook for Employers, is found at the web address that is shown on the second line from the bottom. And finally, we have a web app that will work on any mobile device. And it is really wonderful. It's got a lot of utilities for calculating overtime pay and unemployment benefits and determining liability under various unemployment laws, or employment-related laws. So take a look at that. Now, let me go to the next slide, and I want to cover right quick a wonderful little department in the Texas Department of Insurance called OshCon, and we ran out of time to mention this last time. I meant to mention it at the very end of the lunchtime live webinar, but we just ran out of time. But I'd like to call everybody's attention to this. It's a free, no-cost program available through the Division of Workers' Compensation at the Texas Department of Insurance. And they provide OSHA-level expert safety and health consultation and advice to employers to help them avoid problems with any OSHA-related guidelines. So it's a good way to find out before you get some kind of trouble with OSHA, the federal agency. Find out if something needs to be improved or made safer at the workplace, and they can save you a lot of time and trouble and money. Okay, Now, getting on to the main topic here, payroll taxes. Remember that payroll taxes, federal and Texas, are owed on wages. And wages are basically the compensation or remuneration, to use the fancy word, in return for personal services rendered to the company by a worker. On the federal side, there's withholding tax, FICA and Medicare tax, federal unemployment tax. On the Texas side, under Texas state law, we have only one payroll tax, and that's the state unemployment tax that you pay to the TWC. And the payroll tax is owed on the wages paid to employees. Independent contractors don't come under the payroll tax laws, but you have to be sure about the status of a worker. Generally speaking, anyone who performs services for pay, personal services in return for pay, is presumed to be an employee if they're doing the work of the company. Now, some quick advice. Before you do anything else with a new hire, get them to fill out and sign a W-4 form. You have the legal right as an employer to require an employee to submit a properly completed W-4. Do that before they do any work. The reason is that if they do any work, they're going to earn wages. And in order to properly report the wages to the TWC and the IRS, you're going to need their name and social security number in order to do it easily. So get that information from them. If they quit suddenly and you don't have that information, it's possible to report the wages and pay the tax, but it's going to require time spent on the telephone with an IRS employee and with a TWC tax department employee. So get the W-4. As far as federal payroll taxes, that's not what this webinar is about. We don't want to take the place of the IRS or your CPA, but on the screen there are links to the best 3 federal publications from the IRS about federal payroll taxes. Publication 15, Publication 15A, and Publication 15B. These are all free downloads. You can download them in PDF format, or you can access them in web page format as well and just browse through as needed, and everything is nicely linked within the document. So I highly recommend those. You can get assistance from the IRS with your federal payroll taxes. The IRS maintains a nationwide directory of its local offices at the address shown at that top link. If you want to talk with somebody over the phone, that can be a difficult issue because everybody's so busy with pandemic-related issues, but telephone assistance is at the link shown in the second item there. Local IRS offices are easier to call on the phone than the national office. As an alternative, consult a CPA or a good payroll use good payroll accounting software. The federal unemployment tax is 6%. That's just hardwired at 6%. It's applied to the first $7,000 of an employee's wages in a calendar year. However, if you operate your business in a state that has a federally compliant unemployment system like Texas does, you get a 90% discount on that federal unemployment tax. Your rate would only be 0.6% of the first $7,000 of each employee's earnings, and 0.6% of $7,000 is $42. So $42 per employee per year. That's not bad. As far as the state unemployment tax is concerned, this is what the TWC collects from employers. This is a tax imposed on employers. Employees do not pay this tax. The employer pays 100% of the cost of the unemployment insurance system in the state and on a federal level. Your federal payroll taxes go to pay for the administration of the program in all 50 states. The state unemployment taxes pay for the unemployment benefits that your former employees receive if they're eligible. And for most employers, the state unemployment tax rate is based on the claim experience that you've had as an employer. How many employees in the past have received unemployment benefits. The rates in Texas are set for new employers at 2.70%. That rate applies for the first 6 calendar quarters of operation for a business. Employers are eligible for an experience rating thereafter. That means a calculated unemployment tax rate. If you don't have any chargebacks during the past 3 years, you'll get the minimum tax rate, which is equal to the replenishment tax plus the 0.1% ETIA rate. Now, statutorily, that 0.1% ETIA rate is built into the minimum tax rate, so you'll get that automatically. This year, it's been 0.31%. It may change next year according to the economic conditions in the state, but that has yet to be seen, as I'll explain in just a minute. If you have chargebacks from unemployment claims during the past 3 years, you'll have a calculated tax rate that will be more than the minimum. That tax rate calculation is set by the legislature. It's part of the Labor Code. It's in Chapter 204, subchapters C and D of the Labor Code have all of the components of the tax rate computation. The central component is called the benefit ratio, and that's just basically your 3-year chargeback total divided by the 3-year taxable wage total. The 3-year period, the so-called look-back period used for the tax rate calculation, ends on September 30th of the year before the tax rate goes into effect. So your 2020 tax rate depends upon what your 3-year chargeback total and your 3-year taxable wage total were for the 3-year period ending September 30th, 2019. Your 2021 tax rate will depend upon the 3-year chargeback total and the 3-year taxable wage total ending on September 30th of this year. And again, the 2021 tax rate is in the process of being calculated for all employers that are private taxed employers. Generally speaking, if you have a higher chargeback total, you'll have a higher benefit ratio and a higher unemployment tax rate. If you have a lower chargeback total, that means your benefit ratio will be lower and your tax rate will be lower. Be careful though, because if you have a higher taxable wage total, that makes your tax rate lower. Only the wages on which unemployment taxes have been paid can be included in that calculation. So if you have, an outstanding tax bill, that means your taxable wage total will be lower, and that means your tax rate will be higher. So that's an incentive to make sure that all of your unemployment taxes are paid. Now, to finish the tax rate, to get the effective tax rate that is applied to the first $9,000 of each employee's earnings in a calendar year to get to the state unemployment tax that you have to pay the TWC, what you do is you multiply the benefit ratio by the replenishment ratio to get the general tax rate. And then the general tax rate is adjusted by adding the replenishment tax and the deficit tax if there's a deficit in the state unemployment trust fund, the surplus credit if there's actually a trust fund balance that exceeds the statutory ceiling, which won't happen for 2021. An interest tax if Texas owes interest on a federal unemployment loan, that won't happen for 2021 because the loans that we have taken from the Department of Labor this year to help pay unemployment benefits have been interest-free. Also, there might be an obligation assessment tax if Texas needs to repay bonds issued to pay unemployment benefits. However, we have not issued bonds, so that tax will not be on the table. The effective unemployment tax rate is the result of all of those factors added together. If there is a shortfall in the unemployment insurance trust fund, that is replenished through two different ways. Half of it is recovered through the replenishment tax, which is the minimum tax that all taxed employers owe. The other half is recovered through the replenishment ratio. And remember, the replenishment ratio is only for experience-rated employers. That means employers that have had chargebacks over the past 3 years. Now, all of this admittedly sounds complicated. The tax rate calculation formula is illustrated in detail at the web address that is shown in the third item on this slide. And it's easy enough to find. Just look at the tax department section of our website, and there is a link for how unemployment tax rates are calculated. Each year, the TWC calculates and then publishes the new unemployment tax rates for each employer. As I said before, the look back period ends on September 30th of each year. That's already happened. In October is when the tax department assembles all of the wage and chargeback information needed to calculate the rate. In November, the calculations are carried out, and the aggregate tax rate information is shared with the commissioners. After the first week of December, after about December the 7th, the tax rate notices are mailed out to private taxed employers on a Form C-22. That form will include your 3-year chargeback total and your 3-year taxable wage total, as well as all of the other components of the tax rate. So check that information, and if you think there's anything wrong with it, you would want to contact the TWC regarding a possible appeal. If you have an appeal to file, that can be done under Commission Rule 815.113. That's the so-called Rule 13 appeal process. You can find detailed information about that online at that link that's in the second item there. The commissioners are the ones who make the final decision if a Rule 13 appeal is filed. So basically, any decision or determination of the tax department can be appealed under Commission Rule 13. But the commissioners are the ones who make the decision on that appeal. All right, well, we've reached the end of my time on that presentation, and in the remaining time, I'd like to quickly cover some questions that came in. This may address a question that you have, and if you have an outstanding question, remember, you're always welcome to send it in to that email address that's shown at the very top there, employerinfo@twc.texas.gov. Question number 1, how many hours does an employee have to work before they take lunch? Well, because lunch breaks are optional under Texas law, the lunch break schedule would be determined by the company. Here's another question. Currently, we pay overtime if our field technicians work more than 40 hours a week, regardless if it's a short week. We've implemented weekend on-call rotations. If the employee does not work 40 hours and it's their turn to be on call, should we be paying overtime on the weekend? And the answer is overtime pay doesn't depend upon when the work occurs, unless you've agreed in part of the wage agreement to give them extra pay for working at night or on weekends or on holidays. Overtime pay under the law is owed only if an employee actually works more than 40 hours in a 7-day work week. So just going according to the law, pay overtime pay at time and a half only for hours actually worked in excess of 40 in a 7-day work week. Another question that came in, how do I terminate a work-at-home employee and recover company property? Exactly how your company may terminate the employment of a work-at-home employee is up to the company, but generally you would need to use a documentable way to give effective notice to the employee that his or her services are no longer needed after an effective date. Recovering company property would necessitate a mutual agreement, preferably something that you've already worked out before the need arises, signed by the employee and by a company representative, such as a property return security deposit agreement, an example of which is found in our book on our website. What are the wage rules for salary employees? Do you have to pay them their full weekly wage if they work at any time during the week? Generally, you don't. If an employee misses work because of personal business or illness, you can take a day's worth of pay out of their salary for any full day that they miss. But be careful. With a salaried exempt employee, you can't have partial day deductions from the salary. You can have partial day deductions from paid leave, but not from the salary. Well, all good things must come to an end. Unfortunately, we have run out of time, and at this point, I'm going to turn it back over to the conference coordinator and to Commissioner Demerson if they have any closing comments for the group. Thank you very much.
Well, Tommy, thank you very, very much. I think Kim quite often closes out, but to all of our attendees, we appreciate you guys being here. Very, very, very good information that's been provided by the team, and we're looking forward to answering any questions that you might have. I know information has been provided in regards to our email address and the like. And so, Melissa, Tommy, Mario, great job. And Lunchtime Live will stay tuned to our next Lunchtime Live, and I think Kim may have information on that. And if not, we'll go ahead and close out from that standpoint. Kim, any closing comments?
Yes, our next Lunchtime Live is scheduled for November 19th, where we will be talking about labor market updates, shared work, and teleworking, remote working. So you can go on to the TWC website and register for the next Lunchtime Live, which will be November 19th.
All right, you guys enjoy it. We'll see you next time. Bye-bye.